If you believe your employer violated your rights, one of the most powerful tools available to you is a demand letter. But not all demand letters are created equal. In fact, a poorly written one can seriously hurt your case. Hi, I'm Tom Spiggle, founder of the Spiggle Law Firm, where we help people who have been fired or afraid that they might be. And today, I'm going to walk you through what a demand letter is, why it matters, and what usually goes into it. First, what exactly is a demand letter? A demand letter is a formal written document sent to an employer outlining legal claims and requesting a specific resolution. That resolution might include compensation, reinstatement, policy changes, or other corrective action. It is often the first step toward resolving a workplace dispute without filing a lawsuit. When done correctly, it opens the door to negotiation. When done poorly, it can shut that door completely. A strong demand letter does three important things. First, it signals that you understand your legal rights. Second, it shows the employer that you are prepared to pursue legal action if necessary. Third, it creates an opportunity to resolve the matter privately and efficiently, often saving time, stress, and significant legal costs. Many employment disputes are resolved at this stage, but the key is strategy. Drafting an effective demand letter starts with careful preparation. You need to gather documentation. Emails, performance reviews, text messages, contracts, and company policies can all be critical evidence. Next, you clearly outline the facts. This should be chronological, objective, and specific. Stick to what happened, when it happened, and who was involved. Then, you identify the legal claims. For example, discrimination, retaliation, wrongful termination, unpaid wages, or violations of medical leave laws. Finally, you present a specific demand. This is not just a complaint, it is a proposal for resolution. An effective demand letter should include a clear factual timeline, the legal basis for your claims, evidence supporting your position, a reasonable and specific settlement demand, and finally, a deadline for a response. It should be professional, measured, and legally grounded. What you leave out is just as important. Emotional language, threats, exaggerations, or unsupported accusations can undermine your credibility. Inflated settlement demands without legal justification can signal that you are not negotiating in good faith. And most importantly, inaccurate statements can later be used against you if this dispute escalates. Remember, this letter may be an exhibit in court one day. Even if you ultimately hire an attorney, understanding what goes into a demand letter empowers you. It helps you gather the right information, avoid costly mistakes, and approach the situation strategically instead of emotionally. A demand letter is not just a letter, it is a legal document that sets the tone for everything that follows. If you believe your workplace rights have been violated, the way you begin matters. At the Spiggle Law Firm, we help employees draft strategic, effective demand letters designed to protect their rights and position them for the best possible outcome. Visit SpiggleLaw.com to book a consultation with our firm to understand how we can help with your case today.